this is our second time hosting the workshop. We did this back in May, and we hope to do it at least twice a year because we have two counselors. One is Dolores Madrid Sanders, she's here today, who address tenant and right landlord questions constantly. We get those calls all day long. And so what we're trying to do is be proactive and be in the community to let people know what their rights are. I understand that everybody here is not a renter. You may be a landlord, you may be an agency, but as I was telling somebody earlier, I think with knowledge for everybody, our city can improve. And so that's what we're here to do today. We have several presentations from several folks who deal with housing. Art Crosby will be our first speaker. He is the Executive Director of Lexington Fair Housing Council. After him, Cash O'Chevy will be speaking. He's the Director of Code Enforcement. And then after that, Preston Bell will be speaking. He's an attorney with Legal Aid of the Bluegrass. The last hour, they will all speak for about 15 to 20 minutes. And then the last hour, we'll have a panel discussion. So any questions you may have, they'll be able to answer. In addition to them, Judge Lindsay Hughes Thurston will be here. And so she'll be able to help answer some questions. I need to preface that. Nothing in regards to anything legally related that any case you may have, but she will be able to give some general advice. So we're happy you guys are here. We hope you get some kind of knowledge and get some information. Like I said, our goal is just to make the city better. So I'm going to turn it over to Art.
Thank you. How many people here are tenants? And how many people here are landlords? Okay. And just got a general. Okay. So as we go through, if you have specific questions, things you want me to address, let me know. We kind of want to focus on what you all want us to focus on. I'm going to start a little bit of my presentation, but anytime you want to get me off topic and talk about something else, I'm happy to do that. Again, my name's Art Crosby. I'm with the Lexington Fair Housing Council. We're a nonprofit that operates throughout the state. We provide advocacy for victims of housing discrimination. Part of what we do in our office is also testing. So we'll send out black and white, male and female, an individual with children, an individual without, just to see if people are being treated different. It's part of what our office does. But we also do training and outreach. Our job is to try to keep discrimination from happening in the first place. Which brings me to the question that I like to ask people. Why do people live where they live? How do people decide what's the right spot for them? Give me some thoughts. Affordability. Yeah, that's the number one thing, right? Like, you can't live there if you can't afford to live there. What else? Those factors in. Yeah.
Nearby shopping.
Shopping. Yeah. What else we got?
Schools.
Schools. Yeah. When my friends are talking about buying a house, that seems to be the number one thing they think about.
Bus lines.
Bus lines. Yep. Transportation. Anything else?
Convenient to work.
Convenient to work. Safety. All those kind of things kind of go in. Okay. Now, I want your head to think about the city you live in, Lexington. Can you think about the town, part of the town that's almost all black? Can you think of an area of the town that you live in that's almost all white? The area of town that's almost all Hispanic? Like Cardinal Valley. Why? Why do we have areas of Lexington that are almost all black, almost all white? Why? Any thoughts?
Hispanic.
Mm-hmm.
Near Kingdom.
Geographic purposes? Cultural similarities? But yeah, that clearly is a point where we're at now, but how did that start in the beginning, right? That's the question. How do we get like that? Here's a map, Lexington. You can see the dark parts, over 50% African American. You see parts of different councils. So our council districts are laid out where each council district has roughly the same population, but you can see some council districts have a lot of public housing, some have a lot of Section 8, some have very few. Just about economics. So these purple areas here, there's our areas of Lexington that are both black and poor, but you also have, rich and white in the dark green. So it's not just the economics. Now, the one on your right is where you see evictions. So the high, deep purple is over 100% eviction rate. So it means for every resident that's renting out, every rental property, there's one eviction per year. 100% eviction rate in those properties, right? If you look, a lot of these maps have a lot of similarities, right? Where black live, where minority concentration, where we have Section 8, where evictions happen. This is rental inquiries for help. This is also school proficiency, because we're going to find out as I walk us through here Where you live has a lot to do with a lot of things. A lot to do with your access to jobs, a lot to do with your access to schools. It's not just in Lexington, this is in Louisville. Louisville, the one on your right here. So this is in Louisville, over 50% African American in this area. Less than 4% in the red areas. Same thing with eviction rates, all high, same spots, right? So our housing instability maps a lot with where we focus. Here's our subsidized housing. This is Section 8 in Louisville. Again, a lot of these maps, same map, just different things. So the question becomes, why was that? Anybody know what this is here? It's part from Lexington.
Is that Waveland?
It's Waveland. Right, so the interesting thing about Waveland, it's built in 1845. And Waveland was built. Did the black and white people, are they living completely segregated? No. Pre-Civil War, everybody lived together. Blacks all lived with whites. Why was that? Why were the blacks all living with whites all in the same area of town, pre-Civil War?
Because they provided the work that was.
Absolutely. It's because work and transportation, those two things. We didn't have cars, everybody lived together, right? So it's not something like the segregation thing was something that always existed. It was something that we did over time. So Waveland, you had your slave quarters, right? Same thing as we move forward here. This used to be Eastern State, used to be called the Eastern Kentucky Lunatic Asylum. That one was built in 1824. And again, when it was built, 1824, all the black crazy people and all the white crazy people were all together. It wasn't until 1876 that we said, ooh, can't keep our black crazy people with our white crazy people, and we started separating them out. These things weren't things that just always were. This is what Louisville did in 1914. An ordinance to prevent conflict and ill feeling between the white and colored races in the city of Louisville and to preserve the public peace and promote the general welfare by making reasonable provisions requiring the use of separate blocks for residences, places of abode, and places of assembly by white and colored people respectively. So in 1914, Louisville puts in place an ordinance, tells people where they live. Why? What's the rationale behind this? Why did the government say they need to do this? To promote what? To keep the peace. Mm-hmm. Keep the peace. So 1914, Louisville puts in the ordinance. You have Supreme Court case 1917 said, well, that wasn't a great ordinance. It's not like it violated due process, but basically there was a Supreme Court case where Charles Buchanan was he's a white guy, tried to sell his property to William Worley. Worley was black. Worley couldn't move in because he's black and everybody else living in the property was white. 8 of the 10 houses were occupied by whites. So Worley couldn't move in, says, I don't want to pay you for the property if I can't live there. Buchanan said, yes, you are going to pay me. It goes up to Supreme Court. The Supreme Court decides that basically the white person's got a right to sell his house to a black person, but it's not like it's a due process case. This is how Lexington slowly develops. There you see Ashland Avenue, right? Kramer, this is a whole block of town. You can see this is the incorporation of the property, and I'll use the old language, but I'm just going to read it verbatim. No Negroes can ever own property or live in the park. No business house can be erected within its limits. No adjacent or nearby Negro settlements. Tells you very clear who can live and who can and can't live there. Same thing Louisville. This is a Summit Avenue. You have these kind of restrictive covenants, told who can own what property. Castlewood Drive in Lexington, same kind of thing. Supreme Court eventually said those kind of restrictive covenants were illegal. Well, they didn't say they were illegal. They just said you can't go to the court to enforce them. People were still keeping them. But things started to develop in our city. Louisville, if you're ever down there, Chestnut becomes River Park Drive. Madison, same street, becomes Vermont. It's just how you know where the black people live and where the white people live. It's the way of demarcating the city, which is how everything starts setting up. And then we get into home ownership, right? Before 1930, there wasn't this kind of 30-year mortgage. If you wanted to buy a home, you had to have all the money, right? If grandpa had to die, you had to have it under the mattress. Between 1934 and 1962, the federal government put $120 billion into housing, right? They put it into loans so people could take 30-year loans, pay over time. We really believed in the American dream. The issue, though, is less than 2% of it went to people who weren't white. Over 98% of it went to white people. And it went through this system, which basically, if there were any black people living in the property or in the neighborhood or nearby the property, you're going to get a red. We're going to put you in red. It's all white, then it's green. We're going to put the $120 billion into the green areas. What's going to happen to the prices of those homes as the money keeps going in? Those homes going up in value or down in value? They're going up. $120 billion is being put into those green areas. And let's talk about what home ownership does for people. Right? Here's the three things that I talk about what home ownership does. One is, how many people who've been a tenant have ever had their rent go down? No, never happens, right? Like it always goes up. Sometimes it's 5, sometimes it's 10. Lately, though, it goes up pretty significantly. I mean, it's not unusual for me to have somebody call back and say, my landlord just raised my rent $150, $200. And if you're like me, you're kind of like, you got your budget fixed, but it is where it is. $200 a month can change quite a bit. But with home ownership, your rent stays the same, right? You're on a 30-year fixed rate, doesn't go up. Your over time, you're actually paying off of it, and your home goes up in value, right? Home ownership is a way in America that we create and build equity. And it's not just for us. So in these green areas where that $120 billion went into the white homes, it's not just what happened to that family, it's what happened to the generations afterward, right? Take out a loan, take a mortgage, send your kid to college, they buy a better house. It is a cycle that continues and continues. What happens in the red areas, though? What happened in the areas where we say we're not putting our money in? What happened to those homes? They go up or down in value?
Down.
They went down. Sometimes become foreclosed, sometimes become public housing. This is Bluegrass Aspendale. You can see that 8-foot fence in between the white and black, right? It's not just any fence either. There's some barbed wire on that thing. They want to make sure you know which side of that fence you belong. In the 50s, 80s, white people start moving out of the suburbs. You have realtors who had a code of ethics at the time. A realtor should never be instrumental in introducing into a neighborhood members of any race or nationality whose presence will clearly be detrimental to property values in that neighborhood. This is Carl and Ann Braden in Louisville. So Carl Braden had a friend who wanted to buy a house. Andrew and Charlotte Wade. There's a family. A black family wanted to buy a house in Shively. Shively was a mostly white area. They wanted good schools, good family things, same things we were talking about in the beginning. Carl helped the Wades buy that property because they couldn't buy it on their own. They weren't allowed to. Carl helped them buy it. Within a week of the Wades moving into that house, some people burnt some crosses, threw rocks through the window, and then at the end of the week, there was an explosion underneath their daughter's bedroom. Totaled the house. The Wades wound up moving to the west end of Louisville. Remember that big blue section of black people, right? That's where they wound up moving. Never caught who blew up never caught who threw the rocks. They did, however, convict Carl Braden of sedition for helping that family, black family, buy a house in the white area. So Carl Braden, for helping that black family, was sentenced to $5,000 and 15 years in prison. Carl Braden served about a year before he was released, not because they overturned his particular sentence, but they just overturned sedition. One of the interesting things during this time, the 1950s and 60s, you did have segregated African American areas, but they were doing relatively well. You had pharmacists, you had doctors, you had tailors. They were all kind of developing and maintaining those areas and had thriving businesses. But what happened in that 50s to 60s area where, like in Louisville, you had this middle class houses along Chestnut known as Teachers Row. They come in and they replace it with housing projects and streets, right? The interstate comes through. So what happens then is those pharmacists, the doctors, those are the ones who actually, okay, well, I'll just go move to the suburbs. I'll take my money. I don't have any choice. I'll go move to the suburbs. And you create a more and more segregated economic and racial class that just becomes what it is. That kind of sets up the past to look at how we do today. Today they did testing, right? They look at 12 metropolitan areas, the National Fair Housing Alliance did, and they did testings just to see if people were treated different. So if I'm black, am I treated different when I go look for a home? What percent of the time do you think they found people were treated different based on their race when they were looking for a home? Can you guess?
80?
It's a little bit higher. That's really close.
95.
87% of the time. So if I'm black, where are they showing me? They're showing me Winburn area. If I'm white, then maybe they show me Chevy Chase. Right? It is very specific based on who you look like. And this was even when you controlled for economics. Black people made a little bit more. They still showed you mostly black areas.
And even in Boston, they have housing managers that do that.
So all that, I'm going to go through this quick, but this all impacts everything about you. It impacts your access to banks versus payday lending. In Louisville, there's this tiny town of Anchorage, right? And all the rest of this is Jefferson County Public Schools except Anchorage. Anchorage keeps itself separate. Anchorage has 91% white, less than about 1% black. But the schools are really, really good because you got all rich white kids all going to the same school together. In Lexington, here's your areas with the highest homeless percentage: William Wells Brown, Harrison, Deep Springs, Yates, Mill Creek. The ones with the lowest: Rosa Park, Sandersville, Maxwell, Stonewall, and Veterans Park. And what you'll see, high percent of free and reduced lunch. We're looking 96%. Over here, Rosa Parks is like 9.5%. Non-white, William Wells Brown is 83%, Rosa Parks 34%. They do very different in schools, right? Areas of high concentration of poor children and poor black children do very different than high concentrations of rich white people. Now, it's not just about money. You look, we spend more money at William Wells Brown per pupil than we do at the rest. But the real interesting thing here, look at school average teachers' years of experience. 7, 5, versus over here, 18, 12, 14. How come we think there's the rich schools have teachers with so much more experience?
Because the teachers has to move to those schools.
Yeah, I think that's what it is. I think this is, I don't have statistics to back this up, but I think what happens is the top ones play the minor leagues. You get out of school as a teacher, you have to go do your 5 years, and when you can, you transfer out. They're very different the way their education system. It's not just about money, right? We are putting more money per pupil into William Wells Brown. We have lower student to teacher ratios at William Wells Brown. But we do have 88% free and reduced lunch to 9%, right? It's just a different, when you're hungry, it's harder to learn. Again, yeah, I'm almost, we'll get us there. It's not just Lexington, it's not just Louisville, Berea. This is 1904, criminal indictment against Berea College, the first college to integrate. The state of Kentucky filed criminal charges against Berea for integration. Found it guilty, fine of $1,000, upheld by the Supreme Court. In 1900, you had about 13% of all Madison County farms were black owned. Now it's about 3% black in Berea, right? Things look completely different based on that. Home ownership rates in Lexington, completely different based on race. And kind of get to this question. So I did this training for the New Albany Housing Authorities across the street from Louisville, across the river from Louisville, right? And the new director came in, and when he took over, there was one that they called the black building and one that they called the white building. There's all black people in the black building, all white people in the white building. So new director comes in, he's trying to change that. He's trying to change that old system. So give me some thoughts. How does he change that old system?
Build a new facility, put them all in it.
Right, because here's the issue. They stopped doing discrimination, right? If you're white, but the white people, when they're like, it's all black building, I don't think I feel comfortable there. When a black person came up to the white building, doesn't seem like the right spot for me. Because there was so much of a pattern of the past, it's hard to get people to change from the future. So when you think about how to change it, I really had no explanation except burn them all down and start over again. Practically speaking, it's really difficult to do. But in Lexington, we get a couple of $1 million in affordable housing trust fund money. Where do we put it? Well, we can all agree we need more affordable housing, right? But if you take all $2 million because you can build, let's say, 10 units in Winburn, or one building in Chevy Chase, right? So where do I put it? If I put it all in Winburn, am I fixing the segregation pattern from the past? Am I maintaining it at an even, or am I making it worse? You're actually making it worse. But if I put the one property at Chevy Chase, that's 9 families that won't have a place to live, right? It's not easy. But so I guess my thought, though, is that when we are looking at affordable housing, we talk about not only affordability, but all the things we talked about in the beginning, which is safety, proximity to work, all the things, schools. You try to consider all of that when you decide where to put affordable housing. Okay, so that's my presentation.
All right, good morning. I'm Alex Cash Alchevy. I'm the current Director of Code Enforcement, and I have a slightly different mission than Art's related to the tenant-landlord relationship. I'm the division that's in the middle of all of it usually, because a lot of people don't really understand what code enforcement does per se, because anything that says code, we get calls for all kinds of things. Building codes, permits, a lot of issues that really aren't necessarily ours, but what we are charged with is property maintenance. And that goes for anybody's property, commercial, residential. The only real land we don't deal with are farms, because under Kentucky law, most agricultural properties are exempt from a lot of rules. Obviously, mowing grass on a hayfield would be kind of a mistake, because that's, we actually had a complaint about that last week. Somebody wanted a field mowed out on 62 acres, and it's like, no, we don't make them do that. That's their hayfield. A little late for cutting, but. So what we do under certain ordinances is basically, from a tenant standpoint, we make sure you can call us to help make sure that the property is maintained in a safe, minimum standard of care. And what I mean by that is you have hot water, you have heat, you have a roof over your head, you don't have holes in your siding, you don't have anything that's going to compromise the structure. Now, that doesn't necessarily mean it's going to be painted pretty or necessarily even the cleanest part of the housing. But the idea is there are certain things everybody's entitled to have, and we, under our ordinances, are the division that helps you get that from your landlords. Landlords, on your side, you have the responsibility to maintain your properties regardless. Any owner does. The tenants, we don't hold responsible for anything related to our ordinances. That is where sometimes we get crossways between where tenants, leases, agreements, and covenants between deed restrictions conflict with our enforcement. We cannot do anything about those private agreements. If the landlord decides to let the tenant cut the grass as part of his rent, and the grass doesn't get cut, the landlord's still the one that gets the notice. So that sometimes causes some problems when people don't hold up their end of the deal, and we can't really help you with that. The downside is related to trash, debris, junk vehicles, any of these maintenance issues is we go to the owner, we give them a notice. We'll do an inspection on your behalf, we'll do an inspection based on somebody's complaint, and we will investigate. And whether they're valid or not is kind of up to my officers. We have 20 of them that go around the city to investigate various issues that get called into us. We deal with everything from sidewalks that are broken, junk vehicles, tall weeds and grass, and your housing issues. And we even deal with picking up the road signs that are all in the median. That's our glory job. That's the one we live for. And then we also deal with the snow ordinance, which doesn't have a lot of play here because we hardly ever get that kind of snow that lasts that long. But I've been here since 1979, and we've had a couple of significant snowstorms in those few years. But generally speaking, I can't remember the last time we had any real snow. And it's been even last winter it was cold, but it wasn't really a lot of snow. What, 4 inches maybe we got? But we have those specific ordinances under our purview, and to get to us, all you have to do is call 311. There's an operator switchboard that deals with complaints to the city divisions, and there's a bunch of divisions. There's like 11 of them that, like your Herbie somebody left a Herbie on the street, or there's a pothole, or there's a tree branch hanging over, the stop sign blocked. The operators will send it to the appropriate division, that the best they can tell from the conversation, and that'll get to our staff in a computer system and creates what's called a service request. You don't have to use 311. You can go on the city's website and send it in via email. You can also just, you can do it through actually a web request. There's email, web request, and then the 311 option now. If you want to know where cases are going on and the status of a case, On our website, there's a map for everything that's 90 days current, all over the city. They're little bubbles. It's the 311 page, and we have our own page because we're so popular.
It's also good to keep notes and take pictures of the violation.
Yes.
The violation and.
That's our case building, yes. When we go out to validate these things, we have to go on the assumption that everything can end up in court, because it can, technically. Because we do issue fines, there's rights to appeal, there's rights to hearings, there's the hearing officers that can waive the requirements to an extent of your compliance. They'll give you more time. They don't want those decisions made by staff. You don't need the subjectivity coming from our office. You need an independent third party. And that's why when we go out with our training and say something's broken, if you don't believe it's broken, you can ask us before the citation part comes up. But we take pictures of it. And I'm going to be quite honest, it's a visual thing. I mean, it's like for your tenants and you see it, it's broke. You look at it, it's broken or it's not. Other than testing hot water, if somebody complains that they don't have enough hot water or heat, where we need some measuring devices, most of our job is simply a visual confirmation based on our construction knowledge and what a house is supposed to generally look like. An example would be, if you hung pictures on a wall and your previous tenant put a bunch of wall hangers in there and there's a hole in that wall, is that a violation? A hole in the wall in my book is a violation, but it's for a specific type. Typically, I worry about it between dwelling units where I have rated assemblies, where I have 1 hour walls for protecting tenants from the adjoining tenants. That integrity needs to be maintained. It's not about fixing drywall because somebody punched a hole in it and they got mad. So if the tenant did that, they did that to themselves. They don't generally call us for that. We go into places where doors are busted, cabinets are busted. Those things just generally don't fall off by themselves unless the building's in severe neglect. And that's where the tenant has to take a certain amount of responsibility for the maintenance of their own property related to the landlord. But when we come in there, we don't know who broke anything. All we know is it's broke. And then again, we end up between the landlord and the tenant deciding what their lease agreement was about who may be responsible for fixing it. Ultimately, we just want it fixed. And that's what we do, is we'll issue a notice. That notice is sent to the landlord/owner of the property. They're given a time frame to fix the violations, and depending on the extent of the damage. Example of most housing, we give you 2 months to fix it. Sidewalks, 3 months to fix it. Tall weeds and grass, 14 days. Junk cars, 14 days. Things that are quickly and easily abated. It doesn't take 2 weeks to mow your lawn. Typically, we'll get that call. 10 inches is the minimum, or the maximum the lawn can be. It takes a while for grass to get 10 inches in the city. That means something's happened. Typically, we get, my lawnmower's broke. Well, we got 2 weeks to get it fixed because the neighbors don't want all that weed seed going into their yard and having the dandelions and the thistles and all the other stuff that kind of goes along with it. But the notice goes out to the owner. It's not posted on the property necessarily. That notice gives them time, and basically, that's the kind of stuff we run into. This is a case where the soffit is coming apart. The gutter's falling down. Somebody broke the light fixture cover. The window hasn't been painted for a few years. It starts peeling and the caulk wears off, and then what happens? The wood rots, weather starts going in, broken glass, weather gets in the building, then we got critters, and then we also have the vagrancy issue. And then there's just a spot where a cornice hadn't been painted in a long time, and they say when it's left long enough, it starts to rot. And then it's open into your attic. These are the maintenance issues that go with most older properties. Before aluminum siding, before all the modern maintenance-free stuff of vinyl windows. So we have wood that needs to be protected. Do I have to paint brick to protect it? No, masonry doesn't need any of that for waterproofing or paint. But when somebody paints it, you got to maintain it. To an extent, yes. you repaint it when it starts flaking off the side of the building. But am I really preventing anything by letting my brick go and that paint fading off? That's actually a look now. So don't call me about those, because we're not going to write them up. It may be Art Deco for all I know. But the reality of that is, what some people find annoying or a violation is, it may or may not actually be a violation. And we look at it from the standpoint of, is it hurting the building or the occupants? So what is a nuisance? This poor little puppy gets lost in that tall grass. The real issue with tall grass is the seeds and the weeds that end up in all your neighbors' properties too. A lot of people talk about snakes and rats in tall grass. I'm here to dispel that myth. The snakes like to live under the rocks. They don't hide in grass. They go through it. And most of the snakes all around here are garter snakes. They're harmless. They eat mice, which is a byproduct of a food source. Any animal lives where they have food. Any animal resides where they have cover. You have bunny rabbits in your bushes, right? But nobody ever complains about bunny rabbits. Well, very rarely. We had a picture of a raccoon on a porch. There's raccoons all over the city. They live in the trees, and if they get into those holes in the house, they live in the attics. And then we got to do it. But I'll tell you who's worse than a raccoon is a squirrel. Yep, they will eat right through a wood cornice. My dad had so much trouble keeping them out of his old house. Junk cars. This is for tenants and landlords. Junk cars, by definition, are any car that is inoperable and doesn't have tags, current tags, either or. There is an exception for car collectors, and you have to keep them covered and out of sight of the public view. Obviously, we look at a 55 T-Bird and know that's not a piece of junk. Okay, but it's really hard to call a 96 Cutlass a collector's item. It may be to you, and that's fine, but this is obviously not a restoration job. We run into this a lot. The upside to this is there's no fines associated with this. Typically, we just tow them off. If you don't get them tagged up, they're going to go to the impound. Sidewalks. Another real hazard we have is bushes growing into sidewalks, forcing people to walk towards the street. And so we want them cut back. Mud on sidewalks or make people fall. Somebody asked me last week about leaves. We can't deal with leaves. It's a natural phenomenon. Today they're there, tomorrow they're blown away. The issue would be, I think, if we had an abandoned property and for some reason we had a ton of wet leaves on the ground, we would probably try and clean that up, because wet leaves are slippery. But honestly, they don't stay on the ground very long. I've seen a lot of blowers out in the last 3 days in the new program without the leaf pickup, lots of bagging, but I also see a lot of people leaving them in their grass for mulch. My grandpa believed in that a lot, so it was one of those things where I'm leaving my leaves in there to help my lawn over the winter. So I'm not a big fan of necessarily raking up my leaves. But snow on sidewalks is an ordinance. This could be a tenant landlord thing too, but basically after we get 4 inches of snow in an event, the mayor declares a snow event. Within 24 hours of that event being over, we'll say the storm lasts for 2 days and she says it's done, then the time clock starts on 4 inches of snow or more. We'll come out and give you a notice, give you a day to shovel your sidewalk before a penalty would start. By the time we get out there, usually it's already melted here. We've only had to do this on one parking lot, and it wasn't the parking lot we were trying to cover, but they pushed the snow to the parking lot, blocking the entrance off Southland Drive. So we had to make them move a pile of snow. But that's the only time in the 4.5 years I've been here that we've had to worry about snow on the sidewalk and actually dealing with it. These are the sidewalks that are probably our second most popular thing after the weeds and junk cars. Broken sidewalks. This is a long-term sidewalk that's turned completely back to gravel. These are the ones that we go out and put people under notice for to repair. Those are tripping hazards. We also have accessibility issues with these, but concrete is expensive right now, extremely expensive. We have a program with grant assistance for it, for the owners, for homeowner occupied properties, not rentals and not investment property and not commercial properties, to help offset some of the cost of this. Depending on how much, depending on your financial status, you may get 100% assistance. Typically, everybody gets, the bulk of people get 50% assistance. But we spend over $100,000 a year helping people repair sidewalks. We get a lot of people saying, why are you making this a city sidewalk? There was an ordinance passed way, way back, I think it was 1989, where the owners are responsible for maintaining the right-of-way between the curb and their property line. And that's basically been thrown onto the owners of the property. That's why you shovel the snow, that's why you mow the grass between the curb and the sidewalk. It's simply a process that the city decided they weren't going to do. We've talked about maybe the city taking sidewalks back, but honestly, from a legitimate standpoint of fiscal responsibility, we're getting more sidewalks fixed this way than if we had streets and roads going out and redoing sidewalks, because they'd never get the streets done if they had to do all the sidewalks too. It'd take a huge crew and a lot more equipment for us to take over, you know, a $100,000, $150,000 grant program as opposed to probably actually spending $500,000 a year doing sidewalk maintenance in-house. And this way we're getting the ones that are complained to us the most. We got a neighborhood called in with 158 properties. It actually ended up being about 170 by the time we got done. But neighborhoods tend to come in groups by age, and a lot of it has to do with street trees, buckling the sidewalks, and they're all of a certain time frame of when they were built. So we're getting into Heartland, the Cumberland Hills, the ones that were built 25 years ago when I first started in this business. All those street trees have kind of outgrown their wells, and they're starting to buckle the sidewalks. And so you think about Masterson State, all the stuff that was built in early 2000, when we had a lot of houses being built, almost 2,000 a year for a 5-year run in there. All those neighborhoods are kind of coming to light with us with the street trees. So if you've been sent a notice, what do? Well, my recommendation is comply as soon as you can. But if you have questions about what it is, like I said before, it's a visual thing for us. You can spot it. Your grass is tall, right? It either is or isn't. Your car has tags, it does or it doesn't. It's got flat tires, it does. The gutter's broken or it's not. We ask you to fix it in the timeline. The follow-up is, based on that timeline, the next step is typically a citation from us. And that's our mechanism to generate compliance. It's punitive, it's a fine. So in the process of fining, there's also the right to appeal the fine if you thought we issued you a citation in error, or you disagree with the fact that we called it a violation to begin with. But I still recommend, before the citation part, if you don't think you're really in violation, call our office and we'll come back and look at it again. Our officers have supervisors who will go out and give it a second look, and if ultimately they can't decide, I'll decide. We'll just try and figure out what's going on. The issue for a lot of us, though, is most people don't call us till after they get the citation. And then the only thing I can do is send you to the appeal board for that third-party review. Because now I am not the waiver of all citations. I am not the waiver of liens. Again, that's where the process has gone past us and it's regulated by state law. So you'll want to get to me before you start getting the fines, if you want to. We have financial assistance through grants and special programs for certain homeowners. We have community and resident services that Danielle mentioned. And then I have the sidewalk program, the housing repair assistance program, the housing rehabilitation program, and the emergency housing repair program. We have means to help people fix the properties that need it. You got to reach out, and most of this information can be gotten from us, and it's in your notices to say call us and we'll get you in touch with whoever we think is the most appropriate entity for you to deal with. And with that, we're pretty much, if you got a bill to pay, you don't pay me. It goes right to revenue. We don't collect the funds, and on the basis of that, you don't want us handling them. We're an enforcement agency. And I think a lot of people confuse that with the fact that, again, we need to stay as objectively and in the middle of all these disputes as possible. And sometimes we get leveraged out against other parties, but that's not really what we're there for. But we are there to help keep your properties up on behalf of the general welfare of the whole city, to be honest. And that's what we try and do day in and day out. And if you need us, call us. If it has something to do with us, we will work on it. If not, we'll try and get you in the right division. That's one thing my guys will try and do. If it's not ours, we'll try and get you in touch with the right division in government that might be able to help you. And with that, I'll deal with the questions at the end. Okay.
Okay. Hello, everybody. My name is Preston Bell. I'm a staff attorney at Legal Aid of the Bluegrass. I've represented many tenants facing eviction. We also give advice on other landlord-tenant issues and housing issues. So mine is going to be kind of law-heavy here, my presentation, and it's also geared towards tenants. I know that we have some other people in the room, but this is mainly geared towards informing tenants about what Kentucky law is. I'm specifically going to be talking about what the law is in Lexington, because we have this weird thing in Kentucky where landlord-tenant laws vary from city to city, but I'm going to be focusing on Lexington because we're in Lexington now. Also, I'm not really going to be talking about specific public housing rules or Section 8 rules, though we also cover a lot of those cases, and we've represented tenants in those scenarios as well. Okay, and then, yeah, there should be, we're doing this panel here at the end, and I'd be happy to, take individual questions then. I'm going to kind of go a little quickly here through this, and we can talk more specifically at the end. So just a little bit of a background here. I work at Legal Aid of the Bluegrass. We don't just do housing cases, we do all these other kinds of cases too, government benefits cases, consumer issues like bankruptcy, family law cases, custody cases, protective order cases, a little bit of immigration work, and of course, housing. And this is sort of an overview of what I'm going to be talking about. Stages of tenancy here, entering into a tenancy, obligations of tenancy, addressing some necessary repairs. I'll talk briefly about some domestic violence issues during tenancy, the eviction process generally, and availability of rental assistance. And please, but also if somebody has a question they want answered immediately, please just jump in, because I'm just going to start talking, and somebody should feel free to interrupt me if they have something they want to talk about. So I know we have a lot of tenants in here. I assume that people, well, not every lease agreement is a written lease agreement, although a lot of them are. You can have just an oral agreement with the landlord. Hey, I'm going to pay you $600 a month on, or maybe make it higher considering rental rates here, $1,000 a month, for this two-bedroom apartment for, I'm going to pay on the first of the month, and then if I don't pay by the 5th, it'll be a late fee. So you can have an oral arrangement, but also, a lot of these are determined by written leases. In the absence of a written lease, there is law in Kentucky that will govern the arrangement between the landlord and tenant, who's responsible for what. Okay, so some obligations of tenancy. Well, you got to pay your rent on time. That seems pretty self-explanatory, but I would also add, as someone who has helped a lot of tenants through the eviction process, you are always in a better situation if you've been paying your rent on time. And then I'm going to talk in a little bit about, well, what if there's something really horrible going on at the property, conditions of the property? Is there a way to address that? Is there an option for me to withhold some rent? And yes, there is, and I'll explain it here in a little bit. So in many cases, leases also will require you to do these other things: park in certain areas, pay utilities, keep your home clean, call the landlord if there are necessary repairs that need to be made. They may also have pet policies, a crime-free lease addendum, and violating these other kinds of provisions here can also risk leading towards the eviction process. So it's important that you know your own responsibilities in your lease. Okay, addressing necessary repairs. So can you just stop paying rent because the landlord won't fix something? Well, no, it's not that simple. There are some things that you can do, but you can't just say, I'm not going to pay you because of this issue. You actually have to deliver a pretty specific notice. And so I work at a legal aid organization, and we're happy to help tenants craft these notices to their landlords if they need to deal with it. So these are some of the main options that tenants have in Lexington to address some issues with necessary repairs. And fortunately, we also have Judge Thurston here today who can correct me if I get any of the law wrong. So, and she'll be around for the panel as well. So, one of the biggest remedies that you have as a tenant is you can terminate your lease if there is something that is materially affecting your health and safety and the landlord is not fixing it. You can give, and there's a very specific type of notice that needs to be given here, and I would counsel a tenant to call us or another attorney to try and craft that notice, because there needs to be some specific language in there. But what I find is, I work at Legal Aid and I have a lot of low-income clients, and this is not something that they want to do. Even if the house is in a really horrible situation, they don't have anywhere else to go, and so they don't really want to take advantage of that option to terminate their lease, even if it is in really bad condition. Then there's also something, we call it repair and deduct, where you can deduct up to 1/2 of your month's rent to address something that's materially affecting your health and safety. Now, it's not, it doesn't really resolve every problem, but it can resolve some issues. Again, it's important, the language of the notice here. You have to give a 14-day notice to your landlord and give them an opportunity to fix this problem. And then if they don't after receiving that notice, then you can, but you have to pay the money to fix the problem. You can't just keep the money and pay it towards your credit card bills or your medical bills or whatever. You have to actually, address the problem with whatever the condition is that's a problem. You also, in really bad situations where a tenant is forced out or there's an interruption of utilities or they're locked out, you might be able to get some money damages through what we call an ouster claim, and that's potentially up to 3 months' rent. Although, and our office has given advice to plenty of tenants filing claims on that sort of an issue. Okay, so I'm not going to talk too much about code enforcement because we just had the expert go over here and talk for 20 minutes about it. But just a couple of things clearly from the tenant perspective here is, sometimes, I know that, and I've heard code enforcement doesn't want to just condemn a place immediately if there's some small issues, right? They don't want to jump to that really extreme. That's what I remember from your past lectures here that I've been through. But in some really bad situations where the house is totally falling apart, no working plumbing, tons of electrical outlets not working, structural issues, then it can be difficult for a tenant to decide, because if they call code enforcement when the house is totally in shambles, then code enforcement may come and condemn the place, and that in that effect forces the tenant to leave. Although there are some programs, and so Danielle Sanders at Community and Resident Services, they have a short-term lodging assistance program. There's some others that try and deal with this situation where a tenant gets forced out because of some really horrific conditions. Of course, a lot of it comes down to who's to blame, and I heard that come out in the previous, is that when you all come in, you don't know if it's the who caused the real problems. Is it the property owner? Is it the tenant? And that's always a very live issue in these kinds of housing condition cases, is who's actually at fault. I'm just going to talk pretty briefly about this, but there's some really good protections for victims of domestic violence under Kentucky landlord-tenant law. Basically, if a landlord can't evict a tenant because the tenant was a victim of violence. So if there is some sort of assault that happens, and the tenant living there is, there's property damage to the unit because of the assault, somebody breaks in, a landlord can't just evict that tenant because they violated their lease because they let a guest come in and cause damage to the property. So there are protections in those situations. If the tenant gets a temporary protective order, the landlord is prevented from evicting them for that reason. Also, if the tenant is able to get a longer-term protective order, like a domestic violence order or an interpersonal protective order, the tenant may actually be able to deliver a 30-day notice to their landlord to get out of that lease if they get that longer-term protective order. So those are some really helpful things in Kentucky law that, in my view, are underused. Okay, just speeding through this here, and again, if people have questions, they can hit them with me now, or yeah. What's up?
Do you guys deal anything with ADA violations, Americans with Disabilities Act?
So usually we have great community partners like Lexington Fair Housing Council that we.
I've helped people with some of those cases before, both the landlords and the tenants.
Mhm.
Compliance, but it's kind of a fair section between code enforcement, you guys, and the Fair Housing Act and the Americans with Disabilities Act and federal code of regulations.
Mhm.
That
What-
we are.
What I would say is,
One, I can't say where, but there was one complex here in Lexington recently that had multiple violations. And the district attorney and code enforcement got involved, and some people, like you said, were getting some of their rent, withheld. But there was one tenant that had a HVAC out for 3 weeks, and they weren't making any effort to fix it. And it was real hot at the time. And then there were steps that were cracked, going up to a second and third floor that were a safety hazard. And that had been for 4 months.
yeah, well,
There were some disabled, physically limited people
Sure.
living in that building.
sure. Well, what I would say is that we are on the lookout for those kinds of issues, and when a tenant tells us that there's something that seems that it could be a discrimination, or whether that's disability, race, national origin, gender, whatever it is, then we work pretty closely with Lexington Fair Housing Council, and both our organizations refer clients to each other. So we're not like. There are things, and he would be a better person to talk to. Maybe we can come back to this in the panel a little bit. But we're obviously, we want the fair housing laws to be upheld. Unfortunately, it's not always a great defense in an eviction case if there is some sort of claim discrimination like that. I'm working mostly on evictions, but those are. We want to make sure those laws are upheld, and Lexington Fair Housing Council does a great job of affirmatively going out in the community and doing the tests that they talk about, but also addressing individual situations when there appears to be potential discrimination. So, okay, so these are just sort of 3 broad categories of eviction cases. I'm going to kind of talk briefly about the eviction process. We've got evictions over non-payment of rent, evictions. That might be over a different kind of breach of a lease, like there was the client or the tenant got a criminal charge, for some sort of criminal activity going on in the property, or more simple than that, maybe there's a no pet policy and they have a pet, or an expired lease, and this is what a lot of evictions are about. Just the lease is over and the landlord wants their property back. So. And I'm focusing on these sort of 3 different batches because they each have their own notice period before a landlord has to give this notice, and then at the end of the notice period can file an eviction case. So for non-payment, it's pretty quick. It's 7 days. Landlord has to give the tenant a written notice to pay or vacate within 7 days. If the tenant pays in full what is owed within that 7 days, then they have redeemed the lease and the landlord cannot get an eviction. And if the landlord still proceeds, then that's an eviction defense for the tenant if they paid in full within the 7 days. When there's another type of breach, like we talked about the no pet policy, and then the tenant has a pet, then the owner needs to give a 14-day notice to the tenant. The tenant has 14 days to fix that problem. So if then they can give the pet to their brother or their friend or whoever it is, and then that would be curing that violation. And so they could continue to stay there despite the violation.
Does the notice have to be given a certain way in the 14 days? Obviously, it's written, but does it have to be sent certified mail or hand delivered, or does it matter?
That's a good
Certified mail.
certified. This is certified. I didn't remember off. This is Madison Snelling. She's another legal aid attorney here who works on housing cases. So thank you, Madison. And okay, so last one, holdover tenant. If you've got a year-long lease and that lease expires and then it converts to a month-to-month tenancy. So in a month-to-month tenancy case like this, then a landlord needs to send a 30-day notice renter has to leave within 30 days. If they do, if a tenant moves out prior to the eviction hearing, then the landlord cannot get an eviction judgment against them, although the tenant needs to show up to tell the judge that, because judges don't want to be left in the dark, and they also don't want to enter eviction judgments against tenants if the tenant has actually moved out. So, okay.
Actually,
Sure.
I think you're going to cover this on this slide too, but I just want to make sure it's saying, like, in an eviction here in Lexington, is it the sheriff has to deliver the eviction notice?
The constable is the one who serves the writ of restitution or the writ of possession, which the landlord can obtain as soon as 8 days after the eviction judgment is entered. So it's the constable who serves them all. Who serves all?
From the constable it goes to court, right? Like the constable serving the notice of eviction notice?
Yeah, and they notify the court once they've served it.
I think he
Are
might
you
be
talking about
talking
writ
about
of possession after the judgment? or-
No, maybe I might have missed it, I'm sorry. Like,
Sure.
Like, if the landlord is serving a notice of eviction, is that being delivered by the sheriff or is it being delivered by the constable?
Oh, they don't have to rely. So prior to the eviction hearing, when they serve an eviction notice, that's what you're saying?
Yeah, did I miss this? I'm sorry.
No, that's okay. So that is not required to be served by the constable or the sheriff.
Is it not a formal process? I mean, I believe in lieu, right? Like, or in Jefferson County, the sheriff has to deliver like a notice of eviction before it goes to court.
Well, there's a summons that's issued by the sheriff's office. There's an official court summons, and the tenant has to be given a copy of the complaint. Those are so we got multiple steps here, right? We've got the first eviction notice from the landlord that says you've breached your lease by not paying rent.
Yeah.
Okay, and then they have to give the tenant 7 days in order to fix that. So after that, if the tenant doesn't pay, then at that point the landlord's going to file an eviction case against the tenant, and then those court forms are served by the sheriff or the constable.
Yeah, I don't think there's a statutory requirement
Yeah.
as to who has to serve it. It just has to be served on the tenant to give them notice that they have to be in court.
But the tenant has to be served, right?
Oh, yes.
Yes.
So like, I just, to back up and
No,
state
it's
the room.
not exactly true.
It can't be
Well,
like,
they have to have notice.
like the landlord
That's not
can't
true
send a text
either.
message, right?
Well, that's what I require.
Yeah, but like you could post it on the
Sometimes
Yeah.
Well, so you're talking about personal service versus other kinds of service.
I know
You're-
they do, that's why I'm figuring that out.
Yeah.
It can't be like a text message.
No.
Like from the landlord. or
Yes,
just like a
you're
simple,
right.
like, yeah.
Correct.
That's right. That's right.
Now, you two were disagreeing about that. So if it was served to the property, would you accept a picture of that on the door?
So it does have to be served. It's got to be served in a place likely for the tenant to get it. It is possible that an individual tenant might not receive notice.
Yeah.
But it's at the very least it should be posted on the door and mailed.
Okay.
And I'm remembering a case that I did in front of you where there was argument about how many pieces of tape were put on the on the notice. So these are things that come out in court, and they should be brought up if parties have concerns. So,
And if your name is on the lease, but you're not living there, how are they supposed to let you know that?
We've got a weird system where you can get like, you know, like if I'm going to get sued for money, they got to serve me, and you see like in the TV show where they like serve you with the papers, right? And then you know that person got served. And eviction court doesn't exactly work like that because sometimes you're just suing the property. So you'll list like a whole bunch of people, but you don't even, like you could have a fake name. Somebody could serve me at some other property, and you could have, my name could be on an eviction.
I would say you need to be aware. I would try and get off that lease. If you're on the lease and you're no longer living there, I would try and communicate with the landlord, try and get some sort of amended lease or something that doesn't include you on there. Because what happens is if the other tenant has, breaches the lease in some way, then what they're going to do is they're going to list all the people on that lease, all the tenants on that lease during when they file the eviction case. And so you who have never lived there or who moved out a long time ago, you're going to be at risk of getting an eviction judgment on your record, which is going to affect your ability to get housing in the future, even though you had moved out. So I would try and work with the landlord on getting off the lease.
Yeah, but what if you don't know what's going on?
Well, then try and keep in touch with the other tenants on the lease so that you know.
It has happened. People have gotten evictions that
Yeah.
they had no clue about, and it's on
Yeah.
their record. They don't know for years.
Yeah, I'm trying to explain what the law is, so there may be disagreement about what the law should be. I'm just trying to explain what the law is today. So I'm being told I don't have a ton of time left, so I'm going to kind of, we can get into all these things too at the panel. So just what happens in an eviction hearing. So the landlord will testify as to how the tenant violated the lease. Tenants should bring all of their evidence with them. If that's, text messages, receipts, pictures of bad housing conditions, code enforcement paperwork. They should bring everything that they have to that hearing, and they will get a chance to testify. Although sometimes the tenant needs, it does vary a little bit from judge to judge, and sometimes the tenant needs to be a little forceful about asserting that they have evidence to support their claim. Fortunately, we have one of the good judges here today, so that's not an issue. Okay, I'm just going to talk briefly about rental assistance because it's a great program in Lexington right now. So this originally comes from, there was all this federal money that Congress appropriated starting a couple of years ago in 2020. And so rental assistance funds are available to tenants who are falling behind on rent. And there's also relocation assistance that's helping tenants move into new places with a couple of months rent. There's a maximum of a total of 15 months that a tenant can get out of this program. Rental assistance funds are typically paid directly to the landlord, although there are some new sort of quirks here where sometimes the landlords are not wanting to waive court fees and attorney's fees, and so tenants are getting payments directly that they need to give to their landlord to make payments to make up the past due rent. But this is a really great program, and actually Legal Aid of the Bluegrass has 3 people full-time who are helping tenants fill out rental assistance applications and working them through the process. So it's an excellent program. I'm happy to talk more about it later.
If you have a question, feel free to just raise your hand and ask it away.
Yes. Sure.
This may be something that all of you can speak to. I have a question about emotional support animals. This was never like a thing for us in the past. Like the service animals was very specific paperwork and everything like that. But we're running into this issue where like 9 out of 10 of, thank you.
And there's paper for that.
9 out of 10 of our prospective tenants are saying that they have a emotional support animal. And I'm getting some really conflicting information on the internet as federal law and state law. And then our insurance company. And so I'm kind of curious as to if any of y'all have experience with that, because, I mean, at this point I've been told everything from a bird to a wolf.
There's a peacock too,
apparently.
apparently.
It's illegal to have a domesticated wolf. So, and then our most recent prospective tenant said that she had 3 emotional support animals. We've had somebody tell us that they have emotional support animal that is a pit bull, but our insurance companies won't allow pit bulls. So there just seems to be this major conflict, and I don't really know how to maneuver that.
So that's probably for me.
Yeah.
And I can spend the next 30 minutes talking about sport animals if we really want to get into it. It's kind of the bane of my existence. But so real quick,
Mine too.
I'll try to get through it as quickly as I can. There's a difference between service animals and support animals. Service animals are like what you can take to the library, Target, the mall. Those have to be specially trained, certified. Usually it's like a seeing eye dog, that kind of thing. The law for what you can have in your home is broader, right? So it's whatever, but you do have to have a disability. And it's whatever you need to kind of help accommodate that disability. Now, look, are there examples of this? Somebody doesn't want to pay a pet deposit and they say they have a mental disability just in order to pay a pet deposit or to have their pet bull? Yes, that does happen, right? And if one person in the sorority does it, do other members of the sorority also do that sometimes? Yes. But we also really do live in a society where people are struggling with some very specific mental illness that we can't always see. And when you say 9 out of 10, it might be 9 out of 10 of your residents might actually have, the number of suicides, the number of people just struggling to get through has increased. And certainly I've seen seniors where you take that dog away from them and they pass away within a week. So, but the trick is, they do have to have a disability and they'll need some kind of support for that, some kind of verification that the animal is related to the disability. If it is a support animal, you can't charge a fee, you can't charge a deposit, you can't have breed restrictions or weight limits.
Now, what if that is in conflict, though, with law? Because, Fish and Wildlife tells me that you absolutely cannot have a wolf in your dwelling, that they don't care if it's an emotional support animal or not. Or with our insurance companies, they will not cover, they will drop us if we have residents who have pit bulls.
So pit bulls,
what about when those are in
pit bulls are a
conflict with
breed
each other?
restriction, so that you still have to allow. If there's an insurance issue, I can help you with that.
Okay.
Wolf is something different. I would have to figure out why they say, like, you know, the idea of like I need a dog is something very different. If a doctor is recommending a wolf, that's a new one to me.
Yeah.
Well, and how do we prove that? Because, like, you know, with our most recent one, since she has 3, I find it very difficult to believe that a doctor would think someone would need 3 animals.
So I'd want to know what each one does separately. It's like, so I could very well see somebody who's got a seeing eye dog, right? And also I have some depression. Seeing eye dogs aren't there for emotional support. They're very
But
specific,
they would
right?
be service animals.
Or seizure dog.
Right, or seizure dog, right? But so I can see somebody who has a service dog and a support. It's possible. I've also seen people who have 20 cats, right? Clearly, not all of those cats are providing a different service than the other one, right? So it's got to be reasonable. But that's how lawyers make money too, is because there's some gray area. The other thing for documentation is you do want to document, but there are sometimes websites that will just charge you $50 and they don't do anything. Those really aren't reliable documentation. You're looking for somebody who has some kind of therapeutic relationship, preferably, like I usually say it's in Kentucky, but we do have, if it's through the web, because people do get telehealth sometimes, there is like legitimate stuff through that, but they need to have some kind of therapeutic relationship with them.
So it would be in the form of like a letter from
It
their
should be.
doctor with a letterhead, and it would need to be like a local doctor that says, okay, they have this animal for this specific, and we're allowed to ask what that need is, like.
So
You can ask what they perform for the person, but you can't ask for details under HIPAA.
basically, it's, are they disabled? Do they need this because of their disability?
Because
And I
of
can
disability.
and I can help you through that. And again,
Okay.
if you got something where they're just paying $50 for it, we're not going to count that. But if it does look, even if it looks like they have some relationship, then you're probably going to have to allow it.
Okay, but they would still be responsible for any damages caused by those animals?
Yeah.
Sure,
Okay.
absolutely.
Thank you.
But we do a lot, so feel free to call.
Okay, yeah, because this is coming up like a lot, and I'm like literally like the wolf thing, that was.
The wolf is a
for me.
little
I was
different.
like,
That's
okay.
pretty. It's not going to go away.
Right.
That issue's going to continue.
I have a unique set of circumstances. My daughter's in a very large apartment complex, and they had decided, she went in February as a new tenant, and it took us 3 months to find a place for her to go. And at this point, 95% of the people there, English is not their first language. But the complex just decides to all of a sudden tell us, you're going to have to pay utilities now. Now, they didn't do anything in writing, they just did it. And then 3 or 4 months later, they popped up and they came in and told us all, you got to pay another $100 a month with no upfront. Is that legal?
Was there a written lease for a year-long period?
She has a written lease from the original time she came in February.
Okay, well, then no, I don't think that those changes are.
It's a very large
Yeah.
complex, and I did the math real quick, and they're making a lot of money.
So I have seen that happen a lot recently in terms
Yes.
of people having all of a sudden utility bills that weren't specified. Now, for Preston or I to really comment on that, we'd have to actually review the lease.
Well, they are taking advantage of the Hispanic people because a lot of them cannot speak English. They walk in to pay their rent, they're just told, oh, you owe another $100. And these poor folks are terrified. And I have watched it happen. And I don't live there, my daughter lives there. And I have no place else for her to go. But she's terrified that if we make too much of a mess out of it, or if we tell on them, they're going to throw her out of the apartment complex.
Especially if I'm an undocumented individual or I've had to look forever just to find a house and then there's someplace I'm very vulnerable, and when they start changing things on me, I've never before had people who are so scared about calling or contacting about maintenance
I
because
tried to talk to a couple of people on the sidewalk because I just couldn't believe it. And they were terrified. They kept telling me they didn't speak English when they'd been speaking English to me 5 minutes before.
But if your daughter wants, I can review that lease. I will tell you that as a normal, it is increasingly normal thing to happen where I'm getting more and more people say they just added this fee, wasn't there before. As Preston said, the lease contract's supposed to say what everybody, this is my responsibility, this is what I'm supposed to pay. We also found where people are just burying things within page 15 of the lease that gives them a lot of discretion about what they can pay. And to me, like, that's I think all the material terms of a contract need to be understood, right? Like, this is what my rent is. And this is, we see the same thing with, you know, like utility, internet, right? Like, all of a sudden, you have to use our internet, and it's $100 more. I just think, like, the system works a lot better if everybody knows what am I supposed to pay at the very beginning.
I see a lot of people being bullied and frightened to death, and it really bothers me. It's not right.
I just want to clarify, Preston,
Yeah.
So if the lease was signed in February and it's a year lease that's up in February of 2023, can they go and change the rule that now they have to pay utilities?
No, not, I mean, well, he's right that we would have to look at the lease. I mean, because there might be some, you know, it might be tied to overages over a certain amount, or it's kind of hard to know without knowing the situation. But
the lease may have some specific.
Yeah, but okay, we'll talk about the rent increase. I mean, if the rents, if it says on the lease that, you know, the tenant will pay X amount, and then suddenly they come around and you got to pay X plus 100 in the middle of a year-long lease, that, I mean, with no other facts, that sounds bad. Like that sounds bad. I don't think a landlord could do that. Yeah.
So just in order to help clarify for your specific situation, if you wanted to get the lease to Art, and we have his information over here, then he could look specifically at that to be able to see. Lexington Fair Housing Council. It's on your agenda. The phone number is on there as well.
Okay, thank you all.
Sure.
Let me get him first.
In the past, and I think you know me, I haven't seen you in a long time. In the past, when there was an increase or a change, it had to be in the lease, but if there was an increase in the amount of rent or utilities based on an issue, they had to prove that that issue existed. They had to prove that there was an increase in their maintenance costs in order to raise the rent. They had to provide evidence. I don't know if that still is happening in courts now or not, but in the past it did.
The electric part is really, really difficult, because when I have my electric bill from KU, like, they have to tell me how much I spent. Like, they get my little bars, and right, like, that bar goes up and I can see what I'm spending, and they have to report, here's what my meter said, and if they want to shut me off, they have to go through this whole system. We don't require that. Landlords do, like, I had one tenant who's like, their utility was 50, 50, 50, 400, 400, 400 out of nowhere. Right? And there wasn't really much explanation with it. We don't really require a lot from it's what's in the lease, it's written, but, like, landlords do lately have just been changing the utility game a lot.
Well, I would also, we have an expert from code enforcement here. I would ask you if there's clear, if KU if that's actually traceable to, you know, a bill increasing 8 times. You know, if it went from 50 to 400, is that something? And it's not just, you know, and there's proof that KU is sending out those bills that increase it tenfold or whatever. Is that something that code enforcement could, because I guess the problem with tenants don't feel like they have experts who can come look at these issues. You know, this comes up all the time. My water bill doubled, my electric bill quadrupled, and they don't have as much access to good plumbers, electricians to go in and inspect, and they don't know who the right experts to call to investigate those matters. So
in a sense of whether your water was leaking or your hot water heater was too inefficient or you had a draw on your electric, we would be the division that would at least investigate the fact whether there was a breakage in something. The increase in utility draw is a tough one. From our standpoint, usually an electric issue, electricity is pretty simple. It either works or it doesn't. When it grounds out, it's done. When there's a short, it throws a breaker. Or fuses, if you still have fuses. So typically electric problems like that, an increase in draw and wattage would be something that may be running constantly, like an appliance that's not kicking off. We might be able to indicate that if you knew something was doing. Compressors that start going bad do a lot of cycling and drawing and high amperage, particularly older stuff that's not the new Energy Star and modern appliances. So we could look, but to be honest, we wouldn't be able to necessarily confirm how much amperage is being drawn on an electric. We'd need the bills to kind of help you there too, about how many kilowatts are going out. But the average unit uses about the same. Seasonally speaking, when air conditioning is running, it's this, and then when it's heating season, it's this. HVAC is probably your biggest draw in a unit, and then lighting's next.
Does a tenant have the right to find out how much their specific unit is using a month?
Not under my ordinances, no. There wouldn't be anything to indicate average electric use. And that's basically a lot of age thing with appliances.
The other problem is you're going to go talk to the property manager and they'll say, I don't know, I'm getting it from a Florida bill from a corporation that I have nothing to do with.
Yeah.
So it becomes really hard to track that information down. I think.
That lady, yeah.
Yeah, she was next.
So I actually have two questions. One for you and I think maybe you. Would we call my daughter where she lives at, in the summertime, she has water that like accumulates right in front of her apartment door. I don't know where that water comes from, but it smells like it's swamp water and it's bugs that is around her front door in the summertime. Would she call you guys? She's complained and they didn't do anything about it.
We'd have, again, if we went out and investigated, we would see if we could see where the source of the water was. It's got to be coming from somewhere. Condensate line off an AC unit or downspouts that are broken. Again, only in the summer?
Only in the summertime.
Yeah, that sounds like an air conditioning condensate issue. In which case...
Next door, it's not like that. It's just on her side.
Huh. Again, we'd have to see it to know what it was doing.
Okay.
Because again, code enforcement's pretty visual when it comes to that. You find the water and we find the source, or we look for the source. It's coming from somewhere, right?
Yeah.
It's groundwater, downspout, again, but just by process of elimination. And then when we go out there, it's either there or it's not. Sometimes we get this like, it was there last week, but it's not there this week. By the time we get out there, it's already gone sometimes. Not that happened, but if we can look into the history of the case, if it was not toxic water or just water that was, because in the winter now, like now with it freezing, it would be an ice tripping hazard. But condensate across, we would turn it away from a sidewalk. We would just make them pipe it so it goes into the grass rather than across where you walk. For slipping, tripping, and so on. But for it to be stagnant like that, it'd be a pretty big pool of water.
It is.
I wouldn't think we'd miss that.
It's a lot of water that's just right in front of her door. And she lives, it's called the Hideaway. So at the bottom, she lives downstairs. The apartment on the right, there's no water or anything. So I don't know if the sidewalk kind of leans in or dips in her way, and whatever runs down, it just pools right in front of her door.
Two? Was that?
Yes, I have another question. My second question is, can a landlord deny assistance? So if you are not paying or you cannot pay your rent, can the landlord say, oh, I'm not taking assistance, I don't do assistance?
They can.
Are we talking Section 8, or are we talking relocation assistance through the Housing Stabilization Program?
Like, say I can't pay my rent this month and I need assistance.
Yeah.
And my rent's been paid, I pay my rent every month on time for the last 3 years. But this 1 month I'm having problems and I ask, for somebody to help me, and my landlord says, I don't do assistance.
Do you want to cover it?
They can.
They can?
We cannot force a landlord to contract with the Housing Stabilization Program.
Okay.
And unfortunately, that is a tragic state of affairs, but we can't make them do it. And if they want their property back and they want to move on, that's how it's going to have to be.
Okay.
Would you add anything?
Well, I would just add that relocation assistance is available for people in those situations.
And that's separate and apart, right.
Yeah.
There's the housing stabilization track to be able to stay in your premises and get your rent paid. But then there's the assistance once you're out of the premises after you've been evicted. Now that has nothing to do with the landlord. And the tenant can, they can avail themselves to those resources.
And there's also assistance through Community and Resident Services. We do $1,000 for rent, mortgage, or utility assistance for tenants or residents every 3 years. They're eligible every 3 years. The other thing is sometimes the landlord needs to just speak to somebody to understand the process.
Yeah.
I spoke to somebody last week because in the beginning of housing stabilization, it is true that it was taking landlords a long time to get a check.
Yeah.
They were eventually getting a check, but it was taking several months. And so now the process is expedited. I'll be honest, I'm a landlord. as well. I had a tenant just apply, and within 30 days, I received that check.
And that's a really good point, because in the very beginning of this pandemic, landlords are waiting 6 months, and it was just because of the pressure on the system.
Well, there was also the moratorium.
And the moratorium. But now, we've got a really fine-tuned system now. And I think that you make a really good point, Danielle, that, landlords have bills to pay too. They're not all the devil, right? They have bills to pay too. And so I think it's really great. It's sort of like what we're doing here is communicating, right? If you can communicate to a landlord, hey, you're going to get your money a lot faster than you were, in 2020, I think that helps the process and helps them want to engage.
That landlord didn't even want to hear it.
Right, and that's why I said sometimes you'll see if they'll just speak to somebody, because last week I was dealing with the property manager, and I said, if you'll just let the owner, just talk to the owner and try to explain. But they do have the right to say no.
This program has evolved a lot over the past 2 years. And so I briefly mentioned something called direct tenant payments, or I don't know if I used that phrase, but when the landlord, the traditional way, when the landlord agrees to accept rental assistance from the Housing Stabilization Program, they have to make all these concessions. They have to agree not to waive attorney's fees. They have to agree to waive court fees. They have to agree to waive late fees. They have to agree to extra notice periods, so that if they needed to evict that tenant down the line, they would actually have to wait 2.5 more months than they would normally have to wait to do that. So what a lot of landlords are doing now is say we don't want to agree to all that stuff, and so community action and the rental assistance program in the city have tried to accommodate that by allowing certain scenarios where landlords can still get paid the rental assistance without having to agree to all of that if they don't want to. And I actually like that as a tenant attorney, because I want to persuade that reluctant landlord to let the tenant to stay there, and often the tenants are willing to make some of those concessions in order to have a roof over their head. So.
Ma'am, I know you have a question, and then Tim and then the others, but before the judge leaves, we'll still get to all of them. I just want her to explain what you can expect if you show up in the eviction court, for those who need to know, because that was a question. And so if you could just explain that.
Sure, I'm happy to do that. First of all, I'm so excited that all of y'all are here. This is like the best crowd, and I'm so relieved to see everyone here. I'm suffering from a head cold. I don't have anything else. Just want to put that on the record. So if you don't hear anything else from me today, it is please show up for court. If you are a landlord, please show up for court. And if you are a tenant, or you know a tenant who is facing eviction, please, 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 please urge them to show up for court. If they do not show up for court, I have to take the testimony of the landlord and the landlord's witness, and I have nothing in a defense posture to rebut any of that. A judgment is going to be entered in default, and the tenant will never have been heard. Now, I will say in eviction court, it's in a square box, and it is, we're very confined to what is a defense for non-payment of rent or violating the terms of your lease. But I will listen to you, and all of us, there are 5 district court judges, we will all listen to you. And at the end of the day, we are all trying to figure out a way to not enter a judgment against a tenant. We know the gravity of that, the severity of that, and the weight of that eviction as it follows someone and their history throughout their lives. So please, please, please have people show up for court. That is the most important part of the process, is being able to participate in the proceeding at all. And as far as how the process goes, I think it's been slightly discussed. The landlord I will take the testimony of the landlord. The tenant, again, please, please, please be there, has an opportunity to cross-examine the landlord, to ask the landlord questions. And a lot can come out in that process alone. Then after that, of course, the tenant has an opportunity to testify. And we, again, listen, we consider the testimony. We try to find a way at the end of the day to avoid having to enter an eviction.
Any advice for landlords or tenants in regards to court?
Other than showing up?
Yes.
Just, be patient with the process and each other, and extend grace. Even with, tensions can be very high in landlord-tenant court, which, they should be. The tenant is there because they are facing When you are uprooting a person from their home and their children and their grandmother and their aunts or whoever is living in that home, that is a very big deal. And everyone is very stressed out about that. So for advice, extend grace to each other when you are in that sort of situation. Also for tenants, I think you mentioned this, Preston, if you have documentation of something that you need me to see, please bring it with you. If it's a text message, great, hand me your phone. I'll look at it. It's a lot easier if those messages are printed out, of course. But, you know, I think be prepared because we are going to have a trial that day. If your landlord is seeking judgment against you, it's going to happen that day. It's not going to happen 7 days from now. It's not going to happen 14 days from now. It's going to happen that day.
But you also speak about the new mediation court.
Yes, so that is really Judge Gunther's.
Yeah.
Yes.
We're not really there yet.
We're not.
We're trying hard. We're not.
But this is a new
Yeah.
model that we are working
Yeah.
on for landlords and tenants to get in a room together and mediate their disputes, their complaints. Judge Gunther, who is also a district court judge who will be here tonight for this next session, she is working closely with the Legal Aid of the Bluegrass and the city and Art and all of our community partners to try to stand that up, but I don't think we're in a point to announce that it's actually happening. But
Yeah.
that's okay. That's okay.
You and landlords work with you, but I help with one of the many organizations that helps tenants with rent, and it goes to this lady's question. Our rule is we ask the landlord, you know, do you need a promissory note, and then send it if they do, saying what will help with the organization. But is it true that if they accept their partial payment, then they can't evict them for another 30 days?
Yes. And, you know, that's something that's brought out in the testimony, and, you know, I make sure, you know, in that 7-day window, did you accept anything? Because that is a defense. And if they do, dismissed. See ya.
I thought that, but I was just wondering.
Yeah,
to clarify.
and again, that's why it's so important for us to hear the testimony. It's so important for the land or the tenant to say, well, here is the check that they accepted, and here's the canceled check, and here's the date on it. And if the tenant's not there, you know, I have to take the testimony that is present in court and consider that testimony.
You could have the most intimidating property manager from out of state and the best lawyer for the landlord in Lexington, and if Judge Thurston sees that tenant come in there with the receipt and the landlord, you know, then admits that they paid, then Judge Thurston's going to dismiss the case and rule for the tenant. But you may not even realize that you have a defense until you show up. So.
That's exactly right.
Yeah.
Ma'am in the blue?
Yes, I wonder how much have increased sewer fees and all of this clean water regulations that have come down about having to sewer the water runoff from parking lots. How much has that increased the rents and contributed to the problems and homelessness in the last few years? I know my own personal sewer bill has doubled. Okay, and it is now higher than my water bill. And whether this is passed on or this is something that landlords are expected to absorb.
Well, part of that's going to be negotiated in the lease agreement. Is that not all utility arrangements are the same in different leases. And you might have some where the tenant is agreeing in a lease to pay, you know, either the entire sewer bill or a certain overage over a certain amount, or you might have another lease agreement where the landlord agrees to pay everything. So I think that a lot of that's going to be rental unit to rental unit. Not sure
Have you
about
all looked at that specifically?
I don't know specifically about the effects on rent, but yeah, I don't know.
No, we very rarely do we ever know anything in the leases. That's kind of the disadvantage, I guess, depending on which way you look at it. And our enforcement side is that's a private agreement.
That's one area.
And we don't have anything to do with those.
Cash, that's one area that you all have to consider when you go in and cite people under code enforcement violations, isn't it? Sewerage?
Well, a broken sewer.
Well, yes, and sewers that are overwhelmed by development around a neighborhood.
No, that's actually water quality. That's infrastructure.
But don't you all take that into account?
No,
I
ma'am.
mean, wouldn't you cite somebody for that?
No, that's infrastructure.
Okay,
We wouldn't.
well, then I'm wrong.
Is there another
we-
city agency
And
that would?
I do want to share, I'm not trying to keep plugging my division, but community emergency services, we do assist people with LexServe bills. So if you know somebody who has a LexServe bill and needing assistance with that, right now, it's based on income, but you can get assistance with 50%. I said it's based on income. Is that right, Dolores? Oh, okay. We have 10 programs, so.
Assistance with 50%, you said?
Yes, ma'am, and then you can also sign up for a discount program. So we have a 30 and 50% discount program on certain parts of your sewer bill as well. And so if you grab a pamphlet, it kind of gives you a little bit of information. Like I said, we have about 10 different programs that provide financial assistance, but the LexServe bill is one of them.
10 different ones, huh?
Yes, ma'am.
How are you all marketing that?
Well, there's a flyer right here. We have,
So you do it at meetings like
Yes,
this?
ma'am. We've
You don't
set up-
send this out to the general public?
It's not in the general public, but if you have a problem with your LexServe bill and you call downtown, then they will send you to our division. Like if you're needing assistance.
Okay, and how
with
much
payment.
money is in that fund?
There is $160,000.
150, did you?
60.
160,
Yes,
okay.
ma'am.
Thank you, that's real good information.
No problem. Tim, you had a question?
Yeah, with winter coming and the temperatures dropping, I just wanted to ask a question based on what Alex said, right? With heat, is heat like, is it mandatory? Is it law that landlords provide heat?
Yes, it is.
Absolutely.
Yeah.
65 degrees, 3
only
feet
for
away
7
from the
months.
wall, and 4 feet over the
October to
floor
May.
between
Yeah,
October.
October to May.
October to May.
1st to May.
Wait a minute.
Yeah,
Y'all hear that?
yeah.
Yeah, this is not the
I
time
have
you
a
want to do
question
that.
about what landlords or management companies can do. Recently, our management company has been offering the opportunity for you to have an insurance company that they claim is like a partner with them. And this insurance company is out of Ohio. It is listed in Kentucky as being an insurance company. But basically, you never see anybody from the company. And I think that's selling insurance without a license.
Are we talking about rental insurance?
No. Well, yeah,
Okay.
rental insurance, yeah.
I don't know insurance licensing rules, but I think it's not uncommon for leases to require renter's insurance.
Oh, yeah. Well, we all had our insurance.
I would
They're
think.
trying to put us to a particular group.
I'm not sure that a landlord could force you to go with a particular insurance company. If you did your own research and found another, then I think you would be okay to
some of the
go with
calls
that other
I
one.
get oftentimes is that a landlord is requiring tenants to switch from whatever insurance they have to the landlord's primary insurance company or something like that. So
I wonder if part of this is they need a certain kind of coverage, and so that they're asking that the tenant, there may be some things that are covered in one renter's insurance policy that are not covered in another, and so the landlord is offering a company that they know is going to cover it.
Minimum of 100,000 liability.
But
Well, and their personal property is only 10,000, which I have way more than that, and a college student coming in and renting, they're not going to think about all those things that they have that 10,000 is going to be enough.
I think what they can, if you signed a lease agreement as a tenant that agrees to have certain things covered, now this may be another thing where they shouldn't change it in the middle of the lease term, and they shouldn't tell you, when you start it, you need 10,000 policy, and then when, 6 months later, before the lease is up, you need 100,000. Well, maybe they couldn't do that in the middle of the lease. But I think that they can, if a tenant had agreed to have a certain amount of coverage, they could demand that, whether that's with their own, person that they want to refer you to, or, you found a competitor.
They're taking your money for that insurance. So they're really selling the insurance.
I think what we found is that landlords, and this is going to happen more and more, you're going to have your base rent, and then you're going to have your electric, you're going to have your utility, you're going to have your internet that's going to be required, you're going to have your garbage collection. It's just like when you go on a plane,
Yeah, we have
there's
all
going
that in
to
our
be 20
lease.
different fees, and it's all
The
going to be,
insurance is different as far as I'm
but it's going to be like that too, where they're going to
Our
have,
insurance laws in Kentucky.
and they're going to make money off of all of that.
Yeah, well, but,
Our insurance
I would ask them what coverage they would.
yeah.
Intimidation.
Yeah, well, I mean, you would probably find it, if you went to, competitor insurance company that had all of the coverage requirements required in your lease, and you presented that to your landlord, and then they rejected it, we may be in a different situation, because at that point, they are funneling you to one, even though you've met what's been covered,
But
so.
they're not selling insurance under those conditions?
I'm not, I don't know the law too well there, so I don't want to get too far into insurance selling rules, but.
You know, I've known Ford Health lives in an apartment in Lexington, and they required just $100,000. They had a company that they work with, but, you know, other people that called around for the same coverage or more coverage, it was cheaper. So, you know, they had the right to go to the cheaper insurance, as long as it met that certain coverage.
I'm not saying, I think a landlord could, just because they're recommending somebody, they may have some sort of kickback. I mean, it's possible.
It may also be cheaper if they're referring that many people. It may end up being cheaper too for the tenants because they might get a discount.
Because they're taking the money themselves.
It's hard to, it's hard to say. I think you should, I think if that's a product that you're buying, and I think if you're concerned, then you should look at other insurance companies and then decide
I think you can also ask for a copy of the policy. If you could ask for a copy of the insurance policy, if you're paying for.
Well, they didn't give us that.
Right, but I think you could ask the landlord for that, for a copy of the policy, so that you can verify that you truly are paying for insurance. Ma'am, you had a question in the back?
I did. I'm working with several families who are experiencing like substantial mold overgrowth in their homes. And so they've been working with the landlord, and the landlord comes in and just basically paints over the mold, and then, the mold is there. And these are families that have young children that would have chronic medical conditions, and, so I guess I'm just wondering what kind of recourse these families would have.
It may be a condition that's materially affecting their health and safety.
No, it is. And
Yeah.
I've written letters. I'm their medical social worker for their medical team. But then the landlord still comes in and just paints over and says it's all, okay. And of course,
Sure.
they can't find other housing.
Well, this might be a repair and deduct scenario where they would have to issue a 14-day notice to their landlord specifying the conditions that are materially affecting their health and safety, so the mold. And then they could, if the landlord does not fix that within 14 days, they can deduct up to 1/2 of 1 month's rent to pay somebody to have it done. And that's something that if
But you think that they would need a referral to
well, it's an easier notice for a lawyer to craft, but they could. I just gave you the law just now,
So
so.
it's probably if I'm helping them and I can go further and say there's a repair,
Sure.
they might accept a letter from me saying this.
Yeah, they don't need an attorney to write the letter. I'm just saying that we would be happy to help them.
I don't advise anybody to ever do the repair and deduct letter because it's so limited in terms of how much money you can get. It's probably not going to be enough to fix your mold problem, and you're running the risk of eviction anyways. I just think the repair and deduct, it's such a small amount and it never.
Okay.
It's not as helpful as it should be.
And I
think
termination
it just sucks. Because I get that call all the time, and there doesn't seem to be much that can be done.
From our standpoint, finding the source. Mold grows in a lot of places. A lot of it can be cleaned and gone and just painted over because you can kill it with, there's products, it used to be bleach. Obviously, the odor of bleach is terrible inside the house, but there's other things that dry it off. For us, the source of the moisture, trying to find the cause. It doesn't grow on dry spots. I mean, the mold in a shower is a cleanliness thing. A mold in the corner up in the leaky ceiling where the drywall's turning is a sign of a leak. We got to find the leak to cure the problem. The mold's never going to go away. It's just going to come back. That getting us involved, finding that. I mean, we'll tell the landlord you got to repair the spot, but if we haven't found the source, if the tenant finds and knows where it's coming from, and we can see it, we can actually, like, maybe it's a roof repair, or maybe it's a plumbing leak, but we don't know until we get it repaired. Now, that's the downside about code enforcement. They can cut out the drywall, they can patch it. Eventually, if we go back a third time, we're gonna start asking, there's some other reason this is mold. There is a root cause. Mold doesn't grow by itself. It has to promulgate through the moisture, and it's left to grow, and it won't stop as long as the moisture continues to present itself. Ultimately, it always comes down to water intrusion somewhere and moisture places, like tub shower units. That white caulk that turns, that's mold and mildew. And you as the occupant have to clean your own tub. The drywall damage and paint damage is where that's coming from somewhere else, and we're trying to find it.
I'm not talking about typical mold overgrowth. I mean, I'm talking about pretty severe, like you walk into the house and you see the mold everywhere.
That is excessive humidity.
Okay.
That would be, do they have a lot of plants? Do they have, they run their heat or their air conditioning that doesn't dehumidify? Are they in a basement? Okay, you say there's got to be a cause. But all over, like seeing a wall full of moss.
It's not the landlord's responsibility to help them figure that out. It's the tenant's responsibility.
No,
it may be the
landlords, because it's obviously causing something other than cleanliness.
It's continue to call code enforcement or continue.
Yeah, we have to build the history ourselves. Is that we've been here for mold. It's the same spot. We're obviously not solving the problem. There's a bigger issue. We have the right to ask for professionals to go in, like an electrician, say, you can't just change the smoke detector. You got a breaker tripping. You can't fix it yourself. We want an electrician to certify it.
And one thing that I didn't get a chance to really get into is that we do have a statute that protects against retaliatory evictions. And so when a tenant needs to call code enforcement because of, and they're, it's a real problem that the landlord has just never fixed, and code enforcement comes out and does their job and issues citations and all this stuff. And then the landlord turns around 2 weeks later and says, oh yeah, that dog that's been living here for 5 years that I told you could live here? Oh, they can no longer live here. You're in violation of the lease. Okay, and then they bring an eviction case. That is a retaliatory eviction, and there is a defense to that retaliatory eviction.
But I've never seen up until now the idea of just, I'm not going to renew your lease. Like, you complain, landlord's just not renewing leases, and it's happened.
Well, of course, this is a live legal issue because every time I want to die on the hill of non-renewals can be retaliatory evictions.
I do too, but it's happening.
Yes, yeah,
it's a risk for every tenant.
Yeah.
Yeah, I've got some questions for Cash. So, say if somebody calls in with a mold violation or a mold complaint, on average, how long does it take for you from the day that you get the call till you go out and you inspect?
We're getting response to initial requests within 3 to 5 days.
3 to 5 days. And is there a prioritization sheet? Say if somebody calls right after that and say, I see exposed wires hanging from the ceiling. Do you prioritize based upon?
The real priority is raw sewage and no heat.
Okay.
Lack of utilities. An electric hazard is a priority, but it would have to be a short. I mean, a bare wire didn't just become bare.
Our code enforcement is really responsive. Louisville has a pretty responsive code enforcement.
Okay, so pretty
outside. But you go outside of those.
Yeah, we have to get an appointment in those units. Sometimes the tenants are hard to reach.
Oh, okay.
Okay, because we don't go to the property, we go to the tenant and ask for access. So we got to have a phone number and contact information to make an appointment to get in. Sometimes that can drag us out, but our standard is we respond within 3 days.
And on average, how many complaints do you get a month, and what's your staff like?
Got about 1,200 last month.
Wow. Okay.
We average 9,300 and some a year. This year, we're probably going to exceed that. During COVID, it was less. Quite honestly, we kind of changed our priorities about going into buildings and people wanting us in buildings over things like paint, dirty carpet, wallpaper, caulking. If they were not important issues, we weren't going into people's houses. One, they didn't want us in, and we didn't want to be, as a government, going in and out, possibly spreading it ourselves. So we basically, we didn't shut down, but we were doing emergency entry only for those specific issues. Like I say, an electric hazard is serious, but usually they don't just instantaneously happen. Somebody pulls a smoke detector down or pulls a light fixture off the wall, then I got bare wires. Breakers just don't pop out of panels. We can't have ice storms and storms where weather heads get pulled off of meter bases on the outside of a house, and that's when KU will come out and disconnect you. And then we got to try and get that fixed ASAP. That's one of those things we do. Those kinds of situations, we usually put a notice for 5 days. You got 5 days to fix it. Typically, right, you got to get a contractor out there. That's not something you fix yourself. And then we get that certified, and we get KU back out there to turn you back on.
Okay, thanks.
I have one for Preston probably, and this concerns like the housing stabilization program and the assistance programs, and maybe you can speak on the Healthy at Home as well. But there is quite a few amount of dollars still in those funds, and has there been any talk that you know of to discontinue the kind of COVID relief and rental assistance programs, and what's going to happen to those funds if that program does become discontinued?
So I don't really want to speak on this too much here because I don't work for the city, and the city, this is really, so Community Action is sort of taking management of the housing stabilization program through a grant that they received from the city of Lexington. So what I do, my organization does, is help a lot of tenants apply, and I guide tenants through the eviction process when, rental assistance can help them. But I'm not really, in the know on how long this is, going to go on, or so I sort of direct that more to
I think we've
city.
allocated most of the money we have currently. I think there is trying to get more money at this point. We do have representatives from HUD here. I don't know if they wanted to say.
What was the question? I'm sorry.
Just no, not in that specific. I just meant in general. If you all wanted to say something about HUD.
Yeah, so my name is Timothy Nicolaus with Dave Raley and DeAndre Goatley. We're from HUD. I left my business card up there where the sign-in sheet if anybody wants to grab our business card. If you call us, I am more than likely going to refer you back to one of these fine gentlemen up front, though. But please feel free to call us about anything, anytime. We are here for you, and we try to do the best work we can to help you guys in y'all's situations.
And we had one.
Also, Leander does a great job too.
I work in the Fair Housing and Equal Opportunity Division, so your ADA complaints or emotional support animals or race discrimination, national origin discrimination. I'm happy to talk to anybody about that. If you have questions.
Yes, sir.
Just two quick things. One, is your office, is that the same thing as Community Action, or are you two totally separate?
Two totally separate.
The other thing, someone mentioned about the utilities. You was talking about someone's utility bill going from like 50 to 400. I know just as an example. And something that may help, I don't know for sure, because like just giving them a service technician, where it's electrical plumber, HVAC, I mean, it's $125, $150 just for them to knock on your door. But if there is like a substantial leak like that, I know that you can call KU. I don't know about the gas company or water company, but they will come out for no fee. They will come out and do like a efficiency rating, and I don't think they'll specifically check your HVAC or your refrigerator, but they might look at windows and other areas of openings, where they might see you've got something blocking your compressor motor and on your refrigerator, stuff like that. They might be able to spot things that'll help you. And I don't know if they'll do it for apartments or not, but other ways to make your living space more energy efficient. And that's not a fee, so that could.
I think the water company has one of those too. If you've got a huge increase, the water company will come out and take a look.
It's probably something to call the utility companies as soon as you realize the bill exploding, rather than waiting to a point where it's been 3 months at $400, and so now you owe over $1,000. It's probably something to try and get on at the very beginning. But
water jump's usually a leak. And if you didn't find it in your house, it's outside the house between you and the meter at the front. That's typically what we find on the water jumpage. Electric, not so much. Like I say, it's unusual for it to go that high when an appliance goes bad and starts drawing, because again, electricity kind of works or it doesn't. So the appliance will just eventually kind of short itself out and you start tripping things, and because it's not acting correct. That current, it goes through the whole building. So when like a GFCI or an outlet goes bad, an outlet will go bad. That's not a draw on your electricity. You know, you got to think of the things that actually run and draw amperage. Your refrigerator, your HVAC, your heating water element, your dryer. It's those big amp utility, those big amperage appliances. Almost definitely would be the issue. And of course, that's not necessarily the hard wiring of the house. So, because the wires in the house are the same wires that were in there 50 years ago. The principles of it haven't changed. So there's that dynamic sometimes is, like I said, we can't tell unless we actually hear it or see it and know that it's just whining or sounding funny. Like the HVAC just goes kaboom every time it comes on. That's probably a problem. But KU can also, I think, put meters on to see if you got a draw issue. Okay.
If you find something and your bill is still high, you can always go to the Public Service Commission as well.
Yeah, because they say it may not, again, is the bill artificially been blown up, or am I actually getting my kilowatt hours and reading it and seeing where I got something wrong with it? And that depends on who's paying the bill, which, you know, we can't demand who pays or show me that. It just helps us make that determination.
Any other question on that?
Yeah,
The bill on those,
I'll say,
not the physical readings, but when they do the estimating, they admit that sometimes they're going to be off, and they just kind of tell you to suck it up till next month until they.
well, it doesn't happen a lot, but sometimes we get the, excuse, I call it, well, the computer messed up. They blame it on technology.
I like to blame it all on technology. It's only because I'm not very good with it.
Well, the answer to that is, that's not my problem, that's yours.
We also have a city council person we want to make sure we recognize.
Oh, yes, ma'am. Yes, sir.
Do you want to say something real quick? No?
Hi, my name is Liz Shee, and I'm a council person for Lexington, and I represent the 5th District, which is kind of between Tates Creek and Richmond Road. So that's my area of town, but just for all of you who have questions like this, I would recommend that if you have something going on and you're wondering like who to contact for the issue or what's happening or like following up with something, you have a district council person and then you have 3 at-large council people that you can contact when things arise. But I'm here because I wanted to hear what the conversation is and what's going on in the community, but you know, contact your council people.
Thank you. Sorry, ma'am, go ahead.
That's okay. I was hoping maybe the 3 of you could give some advice on this. We're going to start implementing a new policy in the new year to walk our units twice a year. In 35 years, we've never done that. And it's actually been preempted because of a complaint to code enforcement. We had a tenant do that out of retaliation towards us. And when we went into the unit, we realized that there were several things wrong that she had never reported to us. And your office was great. The lady that I've worked with has been wonderful and told me that this happens sometimes. It started to occur to us, though, that because many of our tenants have been there 20 plus years, that there could be quite a few properties that have things going on inside. I mean, even something as terrible as a water leak that may have not been reported to us, but then obviously it's destroying the property. But then at the end of the day, if they called code enforcement, you know, then the complaint would come on to us about something that we're not even aware of. The biggest thing too is like the smoke detectors and the air filters is what we want to go in and just start changing ourselves, because we just cannot get people to do it. Like the tenants, they just will not do it. So we're going to give them a 90-day notice of walking the units and then schedule those out. But I wondered if any of the 3 of you had recommendations on that, because it's causing me some anxiety to think about going into so many people's, you know, personal homes that they've lived in for a long time. And I want to, like, you know, honor their privacy, but at the same time we do want to make sure, you know, and walk the full houses and make sure that there's
So
not.
one, real quick, the best landlords are ones that care about their asset and are trying to maintain their asset.
Yeah.
So that's great. It's good that you're doing that. Two, I think just really communication in terms of what we're going in there for. Be real clear. Here's where we're going in. Here's what we're going to do. And then have the maintenance or whoever goes in stick to that, right? Like, this is what we're looking for. We're doing it quick and we're out. And I think that's your best bet. Also, if you can, it's always better to have 2 people go,
Yeah,
just so you have an additional.
Okay, I just want to be really respectful about it because I know that since we've never done it, they're going to kind of be like, what?
They'll get used to it later, but.
Yeah, and I think it'll benefit them
Go struggle in the
longer
beginning.
anyways, but. And do you think that's a great idea?
Oh, I strongly encourage that.
I'm really not sure why it hadn't occurred to us before, but it has now.
We are out of time, but if people do have individual questions, we'll stick around here
I
and
think filter
answer.
changes give you an eye.
What is it?
Doing the filters gives
Yes.
you an eye in their play.
And a checklist of the things so that they have, and they know what you're looking for. Then you sign off it and keep it. That's just great for your property maintenance record. And again, they can't turn around and say you didn't check this or that. Now, it's not a broad thing. It's like the smoke detectors, your GFCIs, your appliances, your air filters, the general cleanliness of the apartment is, obviously, the tenant controls that more than you do, but, that would keep it to this stuff.
Right.
The maintenance stuff. If you want the property maintenance code issues, you can get the property maintenance code. It gives you those guidelines of really what has to be kept up by ordinance.
How would I find that?
The International Code Council has it online. We're under the 2021, starting January 1st. We also have some at our office. I can't give them to you. They're copyrighted, but they are available. You can have a property maintenance document.
It's called the International Code of.
The International Property Maintenance Code.
Probably just Google it and.
And then the local amendments are in our Code of Ordinances under Chapter 12.
Also, if you have a bunch of tenants that have been there 20 years, you're doing something right. That's good. That's good.
Well, I don't want to give them like shock.